Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and you can give us a call at 570-307-0702. I am here with you each and every week at this time on this station to bring you, the Pennsylvania property owner, land owner, royalty owner, the information that you need regarding natural gas development in Pennsylvania. So make sure that you tune in each week at this time on this station. And also, if you can't join us each week, you can go to the websites, and this week's show will be up and available tomorrow morning, Monday morning. So you can go to pagasleaseattorney.com. That's pagasleaseattorney.com. You can go to pipelineattorney.com and listen to this week's radio show at your convenience anytime during the week. Also, if you are new to the show, I have been doing the weekly radio show, All Things Marcellus, for you, the Pennsylvania landowner, since August of 2010. So there are many, many hours of radio shows completely free, wide open and available to you at our websites. Again, pagasleaseattorney.com and pipelineattorney.com. Take advantage of the websites. Read the information, listen to some radio shows, be informed, be educated, get the information that you need. The websites, again, everything is free. You can go there, get information. You don't even need to be looking for representation. Just go use them as a resource of quality information to help you, the Pennsylvania landowner, become more informed, more in tune to the issues that we need to be aware of. Deductions, unitizations, all of these items. Go check out the websites. And look, if you have a pipeline right-of-way agreement offered, and you're not going to pipelineattorney.com, what are you doing? Let's get you there, whether you're looking for representation or not. Get to the websites and get this information. You can call us for more information or representation, 570-307-0702. 570-307-0702. At the Clark Law Firm, my focus is on land owner, property owner, royalty owner representation. I have not, I do not, and I will not represent gas or pipeline companies. I represent the Pennsylvania property owner and Pennsylvania royalty owner for such items as gas lease negotiations, gas lease reviews and consultations, pipeline agreement negotiations, reviews and consultations of any type of an agreement, including pipelines. I have negotiated, worked on, reviewed pipeline agreements with over 70 different companies across Pennsylvania. Over 70 companies. Review, negotiate, consult. There's a lot of work out there. There's a lot of experience out there. So let's make sure we're getting you the best possible information. Pipeline agreements, royalty deduction issues, unitization issues, meter sites, compressor sites, well sites, roadways, you name it. Buying and selling oil and gas rights. I'm going to talk about that today. And man, I think about this all the time. I say, well, how can I get surprised? How can I get surprised? Nothing's going to surprise me. Well, I'm going to tell you, I'm going to talk to you today about something that surprised me. And it's going to be something that's not good for the landowner, property owner, royalty owner, in my super strong opinion. What I see as a really bad deal. And that's what we want to do. We want to expose what we think are bad deals, bad agreements, bad offers for landowners, property owners, and royalty owners. So if you're looking for representation, want to learn more about what we do, want to learn about, or what I do, want to learn about reviews and consultations of any type of agreement, I represent property owners, royalty owners, and landowners, not companies, across Pennsylvania. Regardless of your location, I have clients all over Pennsylvania. I've represented people not only all over Pennsylvania, but also all over the country in many different areas of the country, and even people who reside out of the country but have property or gas rights, oil and gas rights in Pennsylvania. You can give us a call, 570-307-0702, 570-307-0702. Don't be afraid to make the call no matter where you're located. Have clients in the southwestern part of the state. Have many clients that I have and continue to represent in north central, Tioga, Lycoming, Bradford, Susquehanna. You name it, any and all gas producing areas of the state. I have probably represented someone in that area. So give us a call, learn more. If you have an agreement, give us a call, find out about reviews and consultations. Can do them in person or over the telephone. Usually start to finish, take 1 to 2 hours, and they have been extremely valuable to the Pennsylvania property owner and royalty owner. So give us a call, learn more about that service. We have received outstanding feedback, and it happens all the time. So give us a call, learn about it, see if we're right for you. Give us a call, 570-307-0702. That's 570-307-0702. We're here to help you. I'm here to help you, the Pennsylvania landowner. So make sure you join us each and every week at this time on this station for all things Marcellus. So, okay, I'm going to jump into it here now, and we are going to talk. Like I said before, I'm not often surprised by bad offers to property owners and to royalty owners here in Pennsylvania. Doesn't surprise me very often because I've seen a lot of them. So it's rare that I get surprised, that I'm really kind of surprised. Now, it's not rare that I'm disappointed in offers, but it's rare that I'm surprised. And in this case, I had someone send me some information that actually surprised me. And in my opinion, and always remember that the radio show was never specific advice for any individual landowner, but what it is general information. We want to get you thinking. We want to have you in tuned to the issues you need to be in tune with, that you're informed, and then you're going to make the best decision. So in this case, I received some information about a company called U.S. Mineral Exchange. U.S. Mineral Exchange. So someone sent me the website information and said, hey, I'd like to get your opinion, want to know what you think about this. Met with somebody and had some interest and wanted to know what your thoughts were. And I'm going to tell you, thankfully, they called. Thankfully, they sent me the information. Thankfully, they've done a review and consultation so they understand what the problems are with this situation, in my opinion. And I think that they're going to make a very wise decision based upon the review and consultation that we did. Unfortunately, though, I fear that people are getting these type of offers, or they're talking to people, they're being presented these types of agreements, these type of listing agreements, and they think, oh, okay, whatever the person's telling me, that sounds really good. I'm going to go ahead and do this. Well, as always, remember that the other side is motivated for their side. They're not motivated to do better for you. They're motivated to do better for them. So we got to really investigate, not what a person tells you. Remember, the landman works for the company, not you, the land owner. So we need to make sure that we're not just listening to words and signing documents, but we're reading the document as well. And we also want to make sure that we're getting independent help. Help actually not independent, but help that's working for you, not the gas or pipeline company. That is very, very important. Though it may seem elementary, super, super important. So in this case, this is a company that is seeking to be a service to connect you as an individual who may be interested in selling your oil and gas rights with a potential buyer who may be interested in purchasing your oil and gas rights. Okay, well, if you're interested in selling your oil and gas rights, maybe this sounds like it's not such a bad idea. To have a third party working what you understand to be on your behalf to try to make sure that you are maximizing the financial payment for the sale of your oil and gas rights. Now, I've talked a lot about buying and selling oil and gas rights in the past. What I'm really focusing on today and what I want to show you and what we're going to talk about is that, and again, I say often, these things, we're going to talk about buying and selling oil and gas rights. And you're going to say, well, geez, what do I care about that? I'm not going to sell my oil and gas rights, so I'm going to tune out and go to a different place and do something else. Well, this show, normally when we talk about an issue, whether it be pipelines, gas leases, buying, selling oil and gas rights, it's not just limited to that topic. In this case, when we talk about buying and selling oil and gas rights, I'm going to explain this listing agreement, some highlights, and some what I see as enormous problems. But this illustrates there are often similar types of problems or loopholes or fine print that you're missing in other agreements as well. So this illustrates how agreements are crafted, how they are drafted to benefit the entity who is drafting the agreements, whether it be a gas company, a pipeline company, a mineral rights company, an exchange company, whatever the case they may be. If you're going to draft the document, you're probably going to draft it in a way that's better for you. Imagine if we could draft our own leases and present them to the gas company. They would be quite a bit different than the leases that many, many people have signed. So, all right, I am going to now get into, as we often do, this is a specific document, and you can go to the U.S. Mineral Exchange website, and you can find their listing agreement. This is from their website, their listing agreement, U.S. Mineral Exchange listing agreement. Now, I could literally, I'm sitting here holding this document. I have writing all over. I have color highlighters, all different colors all over. I think I could talk about this for at least 3 or 4 hours. And that's not an exaggeration. I really do. But I'm not going to do that because we only have 1 hour today. But what I'm going to do is I'm going to highlight several issues and concerns and explain why, in my opinion, and it is a very strong opinion, this is a really bad listing agreement for a property owner, or actually for a gas right owner, oil and gas right owner who's seeking to try to sell their oil and gas rights for the best possible terms. All right, but before I get into the paperwork here, we're coming to the end of the first segment, so I'm gonna cut it off here. Remind everybody, make sure that you tune in each and every week for all things Marcellus at this time on this station, each and every week. Also, you can go to pagasleaseattorney.com, pipelineattorney.com, listen to this week's radio show and many, many, many hours of other shows available on the websites. And if you're looking for information or you want to learn more about our reviews and consultations and all oil and gas representation, give us a call, 570-307-0702. I represent Pennsylvania property owners and royalty owners. Do not, have not, and again, will not represent gas or pipeline companies. Give us a call. Learn what we do. We want to help you. 570-307-0702. 570-307-0702. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure to tune in each week at this time on this station for the information that you need regarding natural gas development in Pennsylvania. And remember, I have not, do not, and will not represent oil and gas companies. So I want to jump in here. I got a lot to cover. I want to talk about the U.S. Mineral Exchange Listing Agreement. So what we have is person wants to sell their oil and gas rights. This could be anywhere in Pennsylvania, could actually be anywhere in the country. They want to sell their oil and gas rights. So they're contacted or they learn of this U.S. Mineral Exchange. Remember, not specific advice or legal advice for anyone. I want to talk about issues that I see in this type of agreement. So this company says, okay, we will work for you, and we have a contract called a listing agreement that you can go to the website, U.S. Mineral Exchange, and go check out their listing agreement. It says, now I'm going to paraphrase, I'm going to read some verbatim. We got, again, a lot to cover. So what happens here is, again, you have a person who wants to sell their oil and gas rights. So let's start diving into these terms, and I will explain where I have some serious concerns, and I think that anybody reading this document would have those same concerns, unless, of course, you drafted or created the document. So, okay, number one, it talks about you. Who are you? And in part, it says that when you sign this, you're agreeing that you have the necessary power and authority to enter into and perform this agreement and carry out the transactions considered under this agreement. Well, you better be sure that you do. Are there any other owners? Is there any type of title issue? Is there any reason in the world that you don't have the complete necessary power to enter into the agreement and sell these oil and gas rights? You need to be aware of that. But I assure you, this is only the surface. It is only the surface. Next, about us. This is on, again, U.S. Mineral Exchange website, about us. And this is verbatim. This is about us, meaning us being U.S. Mineral Exchange. So here's paragraph number 2. The exchange is a listing service. We are not brokers or agents and only act as an intermediary to bring parties together. Now pay attention to this next sentence. You agree the exchange makes absolutely no representations and or warranties of any kind and or nature related to any person or entities you may deal with through our website, including any characteristics related to trustworthiness, creditworthiness, business acumen, financial standing, and or similar characteristics. So this is the entity that you're looking to enter into a listing agreement, saying this literally in a paragraph entitled About Us. Here it is again, verbatim, second sentence, second paragraph. You agree the exchange makes absolutely, the exchange is them, makes absolutely, the entity that you're essentially hiring. You agree the exchange makes absolutely no representations and or warranties of any kind and or nature related to any person or entity you may deal with through our website, including any characteristics related to trustworthiness, creditworthiness, business acumen, financial standing, and or similar characteristics. Ladies and gentlemen, that scares me. I don't know if I want to deal with this website, but that's, again, personal opinion. You are free to do what you'd like to do. This is me explaining some of my opinions and thoughts regarding this document. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can contact us anytime, learn what we do, see if we can help you anywhere in Pennsylvania. 570-307-0702. That's 570-307-0702. And make sure, again, you join us each week at this time for All Things Marcellus on this station. So let's go on. The third paragraph, again, highlighting some things here. It's entitled Title, Liens, Taxes, and Other Such Matters. One of the things that you're stating is you agree that Then again, you go to item number 3, that there are no pending or threatened suits, claims, liens, judgments, violations, encumbrances, mortgages. You agree there are no pending mortgages. If you have a mortgage on your property, you need to read this and say, can I sign this document? If I had a mortgage on my property, there is no way in the world that I would sign this document. You have to pay attention to these documents. These are very, very powerful documents drafted by the other side. I am Attorney Doug Clark. You're listening to All Things Marcellus. Next, again, you're hiring this company. We don't even know yet. Well, I'll jump and tell you that they're going to charge you, and we'll touch on this, a 6% commission. 6%. So if your oil and gas rights sell for $100,000, the commission is $6,000. $6,000. I have an opinion about that, of course, and I don't like it. I don't like it. But again, now we're looking at the listing agreement on the U.S. Mineral Exchange website. We're going next to item number 4, and this is entitled No Advice. You hear me talk about how companies, gas companies, pipeline companies would be very misleading, my opinion, when they have headings that say things like royalty, no deductions, royalties without deductions. But then when you read the language, it's clear that the language beneath that heading doesn't mean what you would think it means, meaning that there will be deductions taken. But the heading is very misleading. In this case, let's give these guys this. They're putting it right there, telling you no advice. Paragraph number 4, no advice. Paragraph 4 verbatim reads, you agree that you have sole responsibility to examine and independently evaluate all offers received, and that is your sole decision to sell or lease your minerals. Nothing on our website or spoken/written through our representatives, their representatives. Nothing on our website or spoken or written through our representatives constitutes sales advice, and you do not have to accept any offer that they're presenting. So let me focus on the first part, because that's the most important. They're telling you, we're not giving you any advice. We're just trying to hook you up with somebody. And we're not going to give you any advice. We're not going to give you any legal advice. We're not going to give you any sales advice. We're just going to try to put you together with someone else. And as you'll hear later, they're going to charge at least a 6% commission. You're listening to All Things Marcellus with Attorney Doug Clark of the Clark Law Firm. Join me each week at this time on this station. Next, we're going to jump to item number 6, saying that you agree that the properties you are selling are not intended or considered by the exchange to be securities or fractionalized interests. Well, you better know what that means. What if you only own a partial interest? Is that a violation? You better know. And you know why? Again, I'm going to jump. You know why? Because if there is ever a dispute under this listing agreement, and please pay attention to what I'm about to say. If there is a dispute under this agreement, and boy, are there many, many areas where disputes can arise, and they're not good for you, in my opinion. If there is a dispute, let's go to dispute resolution item 14 on this same document. The terms of this agreement and or any dispute between the parties shall be governed by the substantive law of the state of Oklahoma. Well, what do you know about Oklahoma law? What do Pennsylvania attorneys know about Oklahoma law? Well, most, not very much at all. Why would they? We're in Pennsylvania. Next sentence in dispute resolution. This is a killer. This is a killer for you if you sign this document, in my opinion. Okay, next sentence. Each party irrevocably agrees that any suit, action, or proceeding arising out of or relating to this agreement, that would be this listing agreement I'm reading from, shall, which is a mandatory term, shall be exclusively instituted, meaning started, shall be exclusively instituted in any court located in Tulsa County, Oklahoma. So, if there's ever a problem with this agreement, if you ever feel that there is a breach or violation of this agreement, Oklahoma law will be used to determine whether there's a violation. But that's not the worst of it. Any lawsuit related to this agreement has to be started, filed, commenced in Tulsa County, Oklahoma. I would venture that most people don't know where it is, but I'm going to tell you it's really darn far away, which means you're going to need an Oklahoma lawyer, and you're going to have to litigate and go into the courtroom in Oklahoma. Think about the power that gives the other side, knowing that it is going to be so expensive and difficult, and I mean very difficult, to bring an action in Tulsa County, Oklahoma, when you live anywhere in Pennsylvania. You're going to need Oklahoma lawyers. You have to go to court. You're going to have to fly or drive to Oklahoma each and every time. It is going to be cost prohibitive in most cases to ever challenge anything. And when I go on further and you hear about some of the other items in this agreement, and you hear about ways in which you can actually be charged 12% of a sale price, and so you said, well, no, I don't think so. I dispute that. That's not right. You know what? If you're going to try to do that, we're going to actually literally have to go to court. Well, you're going to have to go to court in Oklahoma. And that can be a big deterrent that could end up costing you a lot of money and making you agree or feel that you have to agree to something that you would never agree to, except your only alternative is you have to go to Oklahoma to fight a case. You have to have Oklahoma lawyers. You have Oklahoma law. You have to travel to and from Oklahoma for any court proceeding. Realistically, what are the chances that you're going to do that? And don't you think the company knows that? Don't you think the company knows that? When a company, I don't care if this company, any company, says that you have to sue them in Texas, Oklahoma, California, pick a state far away, that to me tells me a lot that I need to know about that company. Because if you're going to treat people fairly, my opinion, if you're going to treat people fairly, then you shouldn't be worried about lawsuits. And if there's lawsuits, those lawsuits should be able to be brought in the state where the person lives, not across the country. Not across the country. What are you afraid of? What are you afraid of? Ask yourself those questions. If you're being told that if you have a case against us or claim against us and you need to sue us and you feel we breached, you got to sue us in our home state of Texas, Oklahoma, wherever that may be, think about who you're dealing with, what you're dealing with. Again, my opinion, think about those things. We're going to talk about more. It's way worse than this, in my opinion. Way worse. And we're going to talk about it after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're talking about buying and selling oil and gas rights. But again, I represent Pennsylvania landowners all across Pennsylvania for any and all oil and gas related matters. You can give us a call. Learn about reviews and consultations. They usually take only an hour or two. We are here to help you. This is the first you're hearing the show. Go to the websites, pagasleaseattorney.com, pipelineattorney.com. I've been doing the show since August of 2010. So there's a lot of information there. We are here to help you. Again, Doug Clark, Clark Law Firm, have not, do not, and will not represent oil and gas companies. Give us a call, 570-307-0702, anywhere in Pennsylvania. If you have oil and gas rights or property and we can help you, we'd love to do it. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Please make sure you join us each and every week at this time on this station for the information that you, the Pennsylvania property owner and royalty owner, need regarding natural gas development. We are talking about buying and selling oil and gas rights, but the bigger picture here is how contracts drafted by companies, company lawyers, very smart individuals, can be very one-sided and really designed for the benefit of course, their side, not yours. So we're going to continue going through this document, but remember, same principle of a pipeline agreement is going to be drafted heavily in favor of the company. If you are not negotiating these, if you are not changing the terms of the language, you are making a major mistake. You may be missing out on tens of thousands and literally hundreds of thousands of dollars. You may be missing out on critical, vital property protections and limitations on the property. I do these agreements all the time. We negotiate them all the time. Do not leave money and protections on the table because you didn't know to ask or you were unaware of the market and didn't know what your leverage was. We have to make sure you are maximizing your situation. You're listening to All Things Marcellus with me, Attorney Doug Clark. So here we go, back to this U.S. Mineral Exchange. You can go to the internet, Google U.S. Mineral Exchange. This is their listing agreement on their website. These are my opinions. Well, I'm going to read from the document. I'm going to offer some of my opinions. So, okay, commission. I touched on it before. If you accept an offer, this is verbatim. If you accept an offer presented through U.S. Mineral Exchange, you acknowledge and agree that the exchange is paid a commission of 6% of the total final sell price. 6%. My opinion, that's way too high. The buyer's closing agent shall pay this commission directly to the exchange at closing. Well, yeah. So you say, oh, yeah, but don't worry, you don't pay this. Well, if the buyer was going to pay the commission, the buyer would have also, I would assume, paid you that money anyway. So that's a really nice way to say, oh, well, you don't pay the commission, the buyer does. Well, if that commission is $20,000, $10,000, $30,000, that most likely is money that you, as the seller of your oil and gas rights, could have received by the buyer. My opinion, but I'm pretty strong and pretty firm in that opinion. So let's go on then. You know how we say these companies are smart? Well, check this out. The next item number 9 is called referred buyers. So any buyer who initiates contact, so somebody or an entity or a business that wants to buy your oil and gas rights, any buyer who initiates contact or accesses the listing, meaning your oil and gas listing that would be on this website, any buyer who initiates contact or accesses the listing through U.S. Mineral Exchange during the term of this agreement is considered a referred buyer. Any direct contact you receive from buyers outside of the U.S. Mineral Exchange. So if somebody writes you a letter or contacts you and says, hey, we want to buy your oil and gas rights, this is the sentence that would apply to them. Any direct contact, independent of this service, any direct contact that you receive from buyers, any buyer outside of the Mineral Exchange during the term of this agreement, they are also considered referred buyers, meaning they're considered as though you learned of them or they were directed to you through the U.S. Mineral Exchange, even if they had nothing in the world to do with this offer. And if this offer was, $5,000 more per acre than what you were getting through this Mineral Exchange service, that still counts as though it was an offer brought by Mineral Exchange, meaning the 6% commission would still apply. So it goes on. Any referred buyer who purchases your property during the term of the agreement or within 90 business days following the agreement is subject to the 6% commission. Goes on. Again, you say, well, I'll be slick. Maybe I'll sign up with these guys, but then I'll just, I'll wait, or I won't tell them, and I'll be, kind of a bit sneaky. Well, again, these guys aren't stupid. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus, and you can contact the office directly, 570-307-0702. So, I say they're not stupid. Circumvention, item number 11, entitled Circumvention. If you circumvent U.S. Mineral Exchange and complete a transaction outside of U.S. Mineral Exchange with a referred buyer, and the buyer does not, remember, referred buyer isn't just because they came through you through Mineral Exchange. They could come to you totally independently. And if this contract is in place, this listing agreement, it counts as though it was brought to you by this service. So it says, if you circumvent them and complete a transaction outside of them with a referred buyer, and the buyer doesn't pay the exchange, that's this service, the 6% commission, you must pay the 6% commission. But it gets worse. Goes on to state, please pay attention. You also acknowledge that the circumventing of U.S. Mineral Exchange damages our reputation in the industry. If you circumvent U.S. Mineral Exchange, you agree to compensate U.S. Mineral Exchange an additional 6%. And the final sales price, so an additional 6% of the total sale, and the final sales price for damages of a total of 12%. So if you try to circumvent them, you are going to be on the hook for 12%. Now, here's something too. Remember we talk about that if there's a lawsuit, you're agreeing that any lawsuit must be brought in Tulsa County, Oklahoma? Well, how about this? How about the company says, hey, you circumvented us. And you say, no, I didn't. And maybe you didn't circumvent them. But they make an argument that you do. And they say, you owe us 12%. And you just sold your gas rights for $200,000. And they're saying you owe us $24,000. You say, no, I don't. I followed the contract. No, I don't. They said, no, we disagree. We think that you violated the contract and circumvented us. So we want $24,000. You say, no, I'm not going to give it to you. And they say, okay, well, then we are going to sue you for breaching this agreement. And by the way, we're going to sue you in Oklahoma. Well, you, ladies and gentlemen, have agreed to jurisdiction of Tulsa County, Oklahoma. So now if they sue you, and even if you say, hey, look, I have a super strong case, they're never going to approve it, you're going to have to defend that case in Tulsa, Oklahoma. So now, if you're sued for $24,000 in this example in Tulsa, Oklahoma, you're going to spend $24,000 in legal fees pretty darn quick. That then means that you may have a decision when the company says, hey, we feel that you owe us $24,000 in my example. And you say, no, I don't. And they say, yeah, you do. And they say, all right, well, we'll let the courts decide. We're going to sue you. And as you recall, because you read the contract carefully, in paragraph 14 entitled Dispute Resolution, you have agreed that any lawsuit must be instituted in any court located in Tulsa County, Oklahoma. So we're going to sue you there. You're going to have to hire Tulsa County, or not Tulsa County. You're going to have to hire all Oklahoma attorneys, someone that's licensed in Oklahoma, and defend this case. hypothetically, and this is me making this up, but what if they say, listen, we won't sue you in Oklahoma, and we think we're right, but we'll resolve this case. Instead of paying us $24,000, pay us $15,000, $10,000, whatever that number may be. And that's where I get into, again, this is hypothetical. But if you think you have a good case and you didn't do anything wrong, you have consented to jurisdiction in Oklahoma, not in New Jersey, not in New York, not in Ohio, not in West Virginia, in Oklahoma. You have a major problem if you are sued in Oklahoma. You have a major problem. And that is why that is in there, in my opinion, to deter lawsuits to be brought against this agency, this U.S. Mineral Exchange. But other companies do this type of thing too. But it's to discourage that, but then also puts you in a really bad position if you're about to be sued or if you get sued. That is an extremely problematic provision. I can't say it enough. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station. So let me tell you. So again, then, circumvention can lead to 12% that you would owe the company of what you sold the oil and gas rights for. But now let's go on and say that here's some more. This is number 12, purchase and sale agreement. If you agree to sell with a referred buyer and you execute a purchase and sale agreement or letter of intent and fail to follow through the terms of the executed agreement, you will be held personally liable for compensating U.S. Mineral Exchange the 6% commission and an additional 6% of the final sales price. A total of 12% is immediately due for damaging our reputation with referred buyers. So there are so many problems with this, in my opinion. Number one, it's talk about you signing a sales agreement letter of intent and not follow through. First off, we haven't seen any sales agreement. We haven't seen any letter of intent. We don't know how these terms are going to be. But ultimately, if you sign it and you fail to follow through, what happens if it turns out you don't own all the oil and gas rights you thought you did? What happens if something beyond your control occurs and you can't follow through? And you have a deal, and we'll just, again, pretend it's $200,000. You now owe 12% or $24,000. And again, I won't go through it all again. If you think, no, I don't, the company says, yes, you do, and they sue you in Oklahoma, what are you going to do about it? What are you going to do about it? You're going to start bleeding money really quickly. You're going to start bleeding money very quickly. All right, I'm up against this segment. I assure you, there is not enough time in an hour show for me to go through all these problems that I see in this. And that's an example where, not to be too commercial, but a review consultation. If you are considering selling your oil and gas rights, I would highly recommend a review and consultation before you go far or very far at all. I do those all the time. We do reviews and consultations done with me. Most of them are over the phone, but you're always welcome to come to the office. We will talk about pros and cons, good and bad, and what your options are. Do not sign these types of agreements without either talking to me or please talk to someone else who knows what they're doing. Don't end up in this trap. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can call me 570-307-0702. Learn what we do. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each week at this time on this station. I'm going to jump right back into this agreement because we need to get to this other section. And again, please know there are many other issues, many other serious issues I have, but this is only a 1 hour show, only a 1 hour show. So, okay, indemnification, real quick on this, and please don't minimize it because I'm going to be quick with it. It says that you agree, this is in part, you agree then to indemnify and hold harmless the exchange, meaning this listing company, from any and all claims, demands, causes of action, or liability whatsoever including costs, expenses, and reasonable attorney fees. You indemnify them. You agree to hold harmless the exchange for any lost sale due to the buyer withdrawing an offer during the time you are listed with the exchange. Very, very, very important. Very important. Now, this is an area that we have to cover. So you may say, well, okay, I already had an offer before I signed up with you guys. I had an offer for $5,000 an acre to buy my oil and gas rights. Well, this says that if you have a prior offer, let me go through it. Any formal written offer that you currently have in hand for the purchase of your property will not be subject to the exchange's 6% commission due and under the following conditions. And wow, are these powerful and not good for you if you're signing this, in my opinion. Number A, or letter A, you have a formal written offer on a buyer's company letterhead. Maybe you do, maybe you don't. But many of these offers are not by companies, but they are by company. Well, they're companies, but they're not going to be the company that actually pays you. Goes on. You are able to provide the written offer to the exchange within 5 calendar days of execution of this listing agreement. So 5 calendar days. You got to get them this offer. Next, letter C. The offer in hand must be current. Well, what is current? Yesterday, last week, last month, 6 months ago? The offer must be current and must not be disclaimed by buyer. Must not be disclaimed by the buyer. If you listen to this show, you've heard me talk about these companies that send these, I'm doing, I hate to do this, air quotes here, saying that this company is making you an offer, but it's highly conditioned. And usually it's disclaimed that they can back out if they don't like this, they don't like that. There's all kinds of disclaimers and conditions. So now again, you may say, well, this prior offer, I like it's legitimate, it's not disclaimed. But this company says, no, that's not a real prior offer because there's disclaimers in there. You say, well, no, there isn't. And later on you get into a fight. Where are you going to be fighting? Oklahoma. This is terrible for you, in my opinion. They've written this to essentially disqualify any prior offers, meaning that if you have an offer for $5,000 per acre, my opinion, you sign with this company, and then you ultimately sign with that same company for $500,000. There's a really good chance you're still going to have to pay a 6% commission because of the way this is worded. And if you dispute that and you say, well, no, that's not correct. There's no way. The company says, no, we disagree. You owe us a 6% commission. Well, no, I don't. They say, well, fine, we're going to sue you in Oklahoma, and you can come answer in Oklahoma whether you owe us a 6% commission or in some cases that we talked about, a 12% commission. I can't say it enough. In Oklahoma, not Pennsylvania, Oklahoma. Any and all claims lawsuits must be initiated, and the jurisdiction you're consenting to is Tulsa County, Oklahoma, not Pennsylvania. Okay, it goes on. Now, again, these previous offers, they have this written so that you're in trouble if you think you have a previous offer and this won't apply. It goes on to state that previous offer you have to sell the property directly to the company or individual listed as a previous offer and not to their affiliated, their DBA or doing business as, their partner, or other entities. Now, here, if you could see me, my arms are flailing. Here's what happens. Again, go back, listen to the shows that we've done, pagasleaseattorney.com, pipelineattorney.com. Listen to the shows on buying and selling oil and gas rights. Listen to me screaming about how the company that sends you this offer is most likely not going to be the company that you sell your gas rights to. The reason is that company gets you to sign paperwork typically. They then go out and try to market your rights to someone else, and then they can get more money, and they make money as the middleman. If they can't get what they need, or they can't get higher than what they've agreed to pay you, there's a good chance that they may back out, or they're going to back out. And now you're going to be stuck there. So these guys are not stupid. They know that. They know that you may have an offer for $5,000 an acre from company X, but they know company X is actually not going to be the company that buys your gas rights for $5,000. Company X is going to have you sign the sales agreement and agree to pay you $5,000, and company X is going to go out and look for somebody else to give them more than $5,000 an acre. Then they will assign their rights to the other company. You will receive $5,000 an acre. Company X will receive the difference of whatever they can find another company to pay over $5,000 an acre. Meaning, if they find another company that pays $6,000 an acre and you have 100 acres, you're going to get what you bargained for, $5,000 an acre, or $500,000. They're going to get an extra $1,000 an acre because they found some other company that would have paid you $6,000, but these guys went out and found them. So now they're going to get $6,000 an acre. They're going to give you $5,000, which is a difference of $1,000. If you have 100 acres, that company, that middleman company, just made $100,000. These companies know, this listing company knows that companies do that. So when you get an offer and you say, well, I already have an offer for $5,000 an acre to sell my rights, so I'm in pretty good shape. Well, the chances are that that offer is disclaimed, so it doesn't count, or that the company that would actually pay you, if indeed you get paid, would not be the same company who actually sent you the offer. They're going to take that offer that they send you, and if you agreed to $5,000 an acre, they're going to go out and they're going to work, and they're going to try to get someone to pay more money, and then they're going to pocket the difference. And these guys know it, which means that what you think is a previous offer, man, is it going to be hard? It's going to be hard to qualify as a previous offer under this agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So I'm running short on time, so I want to get to this last section of this agreement because it's so troubling to me. So, okay, we talked about what these previous or prior offers are and all the different reasons why that's a problem, that you think you have a prior offer, but under this contract, this listing agreement, there's a good chance it will not qualify as a prior offer. At the end of this listing agreement, it says that please list, and you have to provide, remember you have 5 calendar days to provide any other prior offers. So the listing agreement goes on to state that by executing the agreement, you are granting the exchange, which is this company, the right to contact the buyers who you provide that said, hey, I had offers from these companies. They now have the right to contact those companies to verify that the offer meets the terms and conditions above that I just went through, and for this listing agent to work in communication, this is me speaking, in communication with this company you provided them, to secure a higher sales price on your behalf. So they're going to contact those guys and see if they can get a higher number for you. Now it goes on, it says if the exchange causes the sale price to increase directly or indirectly above the amount of your existing offer, we'll keep our example of $5,000 per acre, you agree that the exchange shall be entitled to its full commission due. They're still entitled to their full commission. However, their commission cannot reduce the amount listed that you provide as the offer, and you cannot receive less than what has already been offered to you after the commission is paid. Let me explain real quick because I'm running out of time. $5,000 offer. Let's pretend that you have 100 acres, that's $500,000. They will contact that company and try to get that offer higher. If they can't get it any higher, well, the 6% commission that you would pay them, there's a floor that you can't pay a commission that takes your proceeds below $500,000. However, if they get that number up to, let's say, $530,000 combined, they keep the $30,000 and you still get your $500,000. Not a good deal. Listen, I'm up against it. Man, I could talk about this a long time, but we got to wrap it up there. You are listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, the landman works for the company, not you, the landowner. Let's stop signing bad agreements. Join me each and every week at this time on this station, 570-307-0702. Have a great week, everyone.